What happens when the non-custodial parent moves away? Unless the decree of divorce or decree of parentage or paternity provides otherwise, this is the law that applies in Utah in the event a parent relocates. See Utah Code Section 30-3-37 entitled Relocation. Some people erroneously believe that if a parent relocates a distance of 150 miles or more from the residence of the other parent, that Section 30-3-37 automatically imposes a new custody and parent time schedule. That is not how that section works. We will go through Section 33-37 now and see how it functions in the event of a parent's relocation. First, Section 33-37 covers what a parent who wants to move or relocate must do by way of notifying the other parent. Quote, "For purposes of this section, relocation means moving 150 miles or more from the residence of the other parent." Subsection 2 provides, quote, "The relocating parent shall provide 60 days advance written notice of the intended relocation to the other parent. The written notice of relocation shall contain statements affirming the following. A, the parent time provisions in Utah Code Section 30-3-37 sub 6 or a schedule approved by both parties will be followed, and B, neither parent will interfere with the other's parental rights pursuant to court-ordered parent time arrangements or the schedule approved by both parties. If the parent who receives notice does not object to the relocating parent's impending relocation, then he or she is not required to do anything in response. The relocating parent can relocate, and the parents will either follow a parent time schedule of their own devising, or they will follow the parent time schedule in Section 30-3-37 sub 6 once the relocating parent has relocated. But if the parent who receives notice does object to the relocating parent's impending relocation, then Section 30-3-37 sub 3 through 5 apply. 3 provides, quote, "The court shall, upon motion of any party or upon the court's own motion, schedule a hearing with notice to review the notice of relocation and parent time schedule as provided in Section 30-3-35 and make appropriate orders regarding the parent time and costs for parent time transportation." Sub 4 provides, quote, "In a hearing to review the notice of relocation, the court shall, in determining if the relocation of a custodial parent is in the best interest of the child, consider any factors that the court considers relevant to the determination. If the court determines that relocation is not in the best interest of the child and the custodial parent relocates, the court may order a change of custody." Subsection 5 provides, quote, if the court finds that the relocation is in the best interest of the child, the court shall determine the parent time schedule and allocate the transportation costs that will be incurred for the child to visit the non-custodial parent. This means that the custodial parent who intends to relocate 150 miles or more away from the other parent could become the primary or sole custodial parent as a result of the move, or could become the non-custodial parent as a result of the move, even if that relocating parent were originally awarded sole or primary physical custody of the children. Many primary or sole custodial parents believe that because they were awarded sole or primary physical custody of the children, that means they will always have it, even if they were to relocate 150 miles or more from the other parent. This is not true. A relocation of 150 miles or more from the other parent could result in the custodial parent losing that primary or sole custody, and making the other parent the primary or sole physical custodian as a result, if the court so decides. So what schedule applies if the parties don't agree to a schedule of their own creation or a schedule of the court's own creation? Well, usually it's the schedule in 30-3-37 sub 6, which is, in subsection A, quote, "In years ending in an odd number, the child shall spend the following holidays with the non-custodial parent. Romanet 1, Thanksgiving holiday beginning Wednesday until Sunday. Romanet 2, spring break, if applicable, beginning the last day of school before the holiday until the day before school resumes. In years ending in an even number, the child shall spend the following holidays with the non-custodial parent. Romanet 1, the entire winter school break period, and Romanet 2, the fall school break, beginning the last day of school before the holiday until the day before school resumes. C, extended parent time equal to 1/2 of the summer or off-track time for consecutive weeks. The children should be returned to the custodial home no later than 7 days before school begins. However, this week shall be counted when determining the amount of parent time to be divided between the parents for the summer or off-track period. And D, 1 weekend per month at the option and expense of the non-custodial parent. Section 30-3-37 sub 8 provides more detail on the non-custodial parent's weekend parent time. But the court can set a schedule different from that in Section 30-3-37.6 for children under the age of 5 years. You can see that in Section 30-3-37 sub 7. The remaining subsections of 3337 are subsections 10 through 15, and any parent subject to a Utah decree of divorce or parentage decree with child custody provisions in it who is contemplating relocation needs to be aware of all the provisions in Section 30-3-37, particularly subsection 12, which governs how the cost of parent-time transportation are divided between parents after the relocation of one of the parents a distance of 150 miles or more from the other parent. Pay particular attention to the provisions of Section 30-3-37.12, which governs how those provisions are enforced. Bottom line, if you are a divorcing or separate parent subject to a Utah temporary or permanent order governing child custody and parent time, and if you are contemplating moving 150 miles or more from the other parent's residence, don't do anything until you review Utah Code Section 30-3-37 first and understand what it requires of you and what it can do to you and your relationship with your children.